So this is a sample student brief that was filed in a previous year. And let me point out a couple of things about the brief before we go through it. The first thing is that this was a different kind of brief assignment in that this one did not roll into the appellate brief the way that yours will. And so this was an independent assignment, which was it was completely self-contained. Once they finished this assignment, they went on to a completely different appellate brief assignment, whereas yours are going to roll in so that the feedback you get on the motion assignment will help you directly with the appellate brief assignment, on which you'll be graded at the end of the semester. So that's one difference. And this was also, because this was an independent assignment and didn't roll into the brief, this one was on a shorter timetable, which means this is a somewhat simpler brief assignment than the one that you have. You have longer to do your brief, so it's a more complex assignment. So that's one thing to keep in mind. The other thing to keep in mind is what you're going to see in this video is the brief as originally submitted by the student. I have a version, and we will talk about this as we go through the different parts of trial briefing, that has comments on it, that has some critique on it, that has some corrections made to it. But this is not that. This is the brief as originally submitted. I just wanted you to see the formatting and the types of things that the student did. This is certainly a very good brief, and if I had assigned grades on this one definitely would have had an A. Likewise, there's another sample brief that we'll work with on this same problem that was also very well done that we'll look at. So, as with every document that we use in class, this is a sample. It's not a template. It's a different type of issue. It's going to be, while it will certainly follow the organization that we talked about last semester with CREAC and with, the choices between a clustered organization or a consecutive organization. As you know, as you've learned already, every legal issue has to be organized somewhat differently to accommodate the structure of that rule and the cases that interpret the rule. So don't rely on this as a template. You can't go sentence by sentence and draft comparable sentences for your problem and expect to have the same result. But this is a very well-written brief that does follow the principles that we talked about last semester and that we are going to talk about over the next several weeks. To get started, we're going to look at the caption of the case. And you'll remember that when I was talking about trial briefing originally and talking about the process, one of the things I said was that every case is assigned a docket number in that court. And so that's one of the elements that you see here in the caption of the case. So at the very top of the page, you see the identification of the court in which the case is filed. And then below that, you see the names of the parties involved on the left side, and then you see the docket number of the case on the right side. Sometimes they're identified as criminal action or civil action. Sometimes they're just identified by a plain number without reference to whether it's criminal or civil. Because you have documents that have already been filed in your case, you have a complaint, you have a response, you can be guided by the headings. All of the information that you need for the caption of your case is already in those other documents. And so that's where you're going to find that information. Okay, so the basic components of the trial brief are an introduction, which you see here, and then a statement of facts, which you see here, and then the argument itself, which, as you can see, is organized very much like an argument that you would have used last semester. And then the final part of the brief, we're getting there, is the prayer or the conclusion. In some courts, it's called a prayer. In some, it's a conclusion. In trial court, generally, we call it a prayer. In appellate court, it will depend on what the court rules tell you to do. And so when we get to the appellate brief, we'll talk about what this particular section is called. But it's basically the conclusion that reminds the court what it is that you want and why you think you are entitled to it. And then finally, there is the signature block and the certificate of service. Certificate of service is a new element. Signature block is a new element. And of course, the caption is a new element. But the substantive parts, the introduction, the facts, and the introduction, the facts, the argument, and the prayer, those are all variations on things that you already know how to do. And so remember that we said that the documents that you drafted last semester had a question presented, a short answer, a statement of facts, a discussion, and a conclusion. And those are the 5 sections that every analytical document will have. And then when we did the letters, you saw that you also had those 5 sections. You had an introductory paragraph that identified the issue and gave the answer, or it should have done those things, followed by a recitation of the facts, but targeted to a different audience. Instead of a legal audience, this went to a lay audience. And then finally, you had a discussion of the relevant legal principles. And again, that was in the same order as when you did the memo, but it was targeted to a different kind of audience. It was a lay audience instead of a legal audience. And then finally, at the very end, you had a conclusion and some recommendations, just like you had a conclusion in the memo. So this works the same way. You've got an introduction, which basically identifies the issue and gives the answer. After that, you have a fact section. You have an argument section, and this is the discussion of legal principles. In the memo, it was called a discussion. In a persuasive document, it's going to be called an argument. And then finally, at the end, you have the prayer, which serves the same function as the conclusion in an evaluative document. Okay, so those 5 elements are the same. The only thing that's new here is the caption at the beginning, and then the signature block and the certificate of service at the end. So I think the purpose of the heading is pretty obvious. It's so that you can identify which case this particular document should be filed with in the court clerk's office, and so the judge will know which parties and which case this relates to when it comes across his or her desk. So that serves the same function as the memo heading. It serves the same function as the heading in a letter that gives the addressee's address and the salutation and the subject line and all of those things. So that's a variation on something you've already seen before, and I think the purpose is pretty self-explanatory. At the end, the signature block at the end, this is, first of all, to identify who counsel of record is, but also to bind you to your work product. You are attesting by signing this that this is not a frivolous action, that the research that you have done is thorough and that it's accurate, and that you stand by this work product. You stand by these arguments, you stand by this analysis, and that the buck stops with you. That is the purpose, both legally and ethically, of the signature block. So signing these documents has serious significance and serious consequences. The last part is the certificate of service. That's also new. From civil procedure, you learn that every document filed in an action has to be served on the opposing party, and that you have to attest to the fact that it has been served, and it has to be served a particular way. So the certificate of service serves 2 functions. It serves the function of you attesting that you have served the document as you were required under the rules of procedure, and it also attests that you have served the document properly, that you have done it using a method that is approved by the rules of procedure, and that you've sent it to an address that satisfies the rules of procedure with regard to jurisdiction and service. And so that is the purpose of the certificate of service. And so those are 2 things, the signature block and the certificate of service, that you will add to every document that you do that you write from now on. And so you'll see similar elements in the appellate brief. Generally, a motion memorandum does not have court rules associated with it. There are the general rules of civil procedure or criminal procedure, which govern service and govern your certification that what you have submitted is not frivolous. But there generally are not detailed requirements with regard to page limits, font size, spacing, margins, and the things that you will find rules for when we talk about appellate briefing. And so you have a lot more latitude with regard to drafting a motion memorandum as to how you're going to structure that document, how you're going to do that organizationally. And so we will talk in a couple of weeks about the best way to format a document when you have the freedom to do it however it is you would like to do it. One of the things you want to keep in mind is that while there aren't detailed rules that the courts have for these documents, the appellate rules give you some guidance in what courts like to see. And so the appellate rules can be helpful in deciding how you want to format your document, but we're going to talk about some variations on that in a couple of weeks that make the document a little bit more effective. And these are the formatting rules we're going to talk about are formatting rules that have been adopted by some courts across the country. Okay, so that's it as far as the structure of the brief. So what you're going to be writing will be an introduction that has the issue and the issue and the answer, a statement of facts, which is going to be a persuasive statement of facts instead of an evaluative statement of facts, which we'll talk about over the next two classes, and then the argument, which again is going to be structured pretty much like the arguments you have used before. We will talk, after we talk about facts, we will talk about some ways in which a persuasive argument differs from an evaluative argument. And then the conclusion, of course, is only different in that in the evaluative documents, both the memo and the letter, your task was to come up with a conclusion that best predicted the outcome. Here, your job is to write a conclusion that supports the outcome that you want. And so now that we're into persuasive documents, we've done the strategizing. We know what the opposing party is going to argue, and so we can structure our argument around it, but our ultimate conclusion will always favor our client. Okay, so that is the basic document. The only part that we will not really discuss in a lot of detail other than today is the introduction. And so the introduction section, you've got one here. The defendant's motion to suppress evidence should be granted because discovery of an arrest warrant is not sufficient to purge the taint of an illegal seizure. So you start with a statement of what you want and why you're entitled to it. So your basic conclusion. The defendant's motion to suppress evidence should be granted. So that's the relief that you want. And the reason that you believe you're entitled to it is because discovery of an arrest warrant is not sufficient to purge the taint of an illegal seizure. Then you go through and give a short justification. The Supreme Court has established that evidence obtained because of an illegal seizure is fruit of the poisonous tree and inadmissible under the exclusionary rule. An exception is when the evidence is discovered through an independent source. This is not applicable. Another possibility is purging the taint of the original illegality by satisfying the Brown factors, but this is also not applicable. The motion to suppress the evidence should be granted because the arrest warrant is not sufficient to purge the evidence of its original taint, and therefore the evidence seized is fruit of the poisonous tree. So you've got three components to your introduction. You've got that first sentence, which is what we want and why we think we're entitled to it. The last sentence is, again, what we want and why we're entitled to it. And then the middle section is basically the short answer, the justification for why we want that. So let's go through this section and talk a little bit about it. The defendant's motion to suppress evidence should be granted. First of all, motion to suppress evidence should be capitalized because it refers to an actual document that has been filed by someone in court. If we were talking about motions to suppress evidence in general, for example, if you had a statement that said, when a defendant wishes to have evidence excluded, he will file a motion to suppress. That would be lowercase letters because it refers to motions to suppress generally. It doesn't refer to a specific document that has been filed in court. Because this one refers to a specific document that has been filed in court, It should be capital letters, M, capital M, capital S, capital E. And then the rest of that sentence is fine. As far as defendant, if you say the defendant, then you're going to have a lowercase d. If you use defendant as a substitute for name and you don't use the with it, then you're going to have a capital D. So capital D when you're using it as a name, lowercase d when you're referring to it as the label. So the defendant's motion to suppress evidence should be granted because discovery of an arrest warrant is not sufficient to purge the taint of an illegal seizure. And then it goes on to give the explanation for that. The Supreme Court has established that evidence obtained because of an illegal seizure is fruit of the poisonous tree and inadmissible under the exclusionary rule. That's the general rule under which all of this analysis falls. That's well stated. That's fine. In the citation, of course, United States should be spelled out. We don't use the abbreviations U.S. in citations. An exception to the exclusionary rule is when the evidence is discovered through an independent source. This is not applicable. There are a couple things about this sentence. Substantively, it's fine. Drafting-wise, there are some issues. An exception is when. Well, an exception is not an event, so an exception can't be referred to as when. You could say an exception to the exclusionary rule is evidence discovered through an independent source. Another thing you could do is just completely restructure the sentence because ultimately this sentence is a comma splice. The comma, this is not applicable. Those are two completely independent clauses and they're just connected with a comma, which is not a proper use of a comma. So you would probably put a semicolon would be fine there if you're comfortable with semicolons. If not, just a period at the end and start again. The better place would be to probably start with evidence discovered through an independent source. So you could start that sentence with evidence discovered through an independent source is not subject to the exclusionary rule or is accepted from the exclusionary rule. That might be a better way to draft that. Again, the citation afterwards, that should be United States instead of U.S. Another possibility is purging the taint of the original illegality by satisfying the Brown factors, but this is also not applicable. And so you're raising another exception. And in doing so, what this writer is doing is showing that the arguments that the opposing party is likely to make are simply not applicable in this situation. And so without even addressing the opposing party, the author has started to undercut the opposing party's arguments. But let's look again at this specific sentence. Another possibility is purging the taint of the original illegality by satisfying the Brown factors. This is a little bit vague because there's no reference to what the Brown factors are. And so a better sentence might be fruit of the poisonous tree may also be purged of its taint by, and then some substantive reference to the Brown factors. But this is also not applicable. Or even because it's not applicable, you could do it more, you could even draft it more simply in saying, in some circumstances, the taint of illegally seized evidence may be purged. However, that is not the case here. So you can get the same way. And then finally, that last sentence, the motion to suppress evidence should be granted. Again, motion, suppress, and evidence should all be capitalized. And that's about it for the introduction. So your introduction is going to have three components. It's going to have the beginning sentence, which tells what you want and why you're entitled to it, a brief justification of that with citations, and then a restatement of what you want and why you should get it. So that's all that we're going to look at for right now with this trial brief. We're going to take this one up again when we talk about persuasive facts. And again, when we talk about persuasive argument, we'll also look at another sample brief. This sample brief and the other sample brief that we'll use will be posted on Twin with the comments that I gave those students on the brief, so you can kind of see where some of the issues are. So that'll be available to you if you'd like to to look at it, and that'll be under the week 4 materials and also under the trial brief assignment folders.